Here's the Stewart.
I was just about to take your lordships to two cases in the House of Lords where these principles have been applied. First of these is Smith's Potato Estates in Bowling, which begins in the bundle on page 1494. The issue in this case was whether legal and accountancy expenses incurred by a trader in contesting the amount of an assessment to excess profits tax were allowable as deductions in computing both income tax and excess profits tax. And this was a majority decision. You can see on page 1495, Viscount Simon and Lord Oaksey dissented. So I'm going to take you to the majority judgments. And if we just turn up to page 1509, Lord Porter and if you'd just like to read from the top of the page, but it is said, down to already earned and computed, which is the second last paragraph.
Yes.
Lord Porter appears to be making both points from Strong and Woodfield. One, the character in which he pays is that of an individual, not a trader. And then also, it's not paid to earn profits. And then, if we move on to 1513, this is Lord Simmons. And it's picking it up about 8 or 9 lines down. The reason is not far to seek, he says. It is neither the cost of ascertaining taxable profits, etc. If you just read that down to the 4 lines into the next page.
So is there then a distinction between the ordinary costs of getting an accountant in to audit your accounts and produce your financial accounts, which presumably I would have thought is tax deductible, but not if there's then an argument with the revenue authority?
Yes, I think what he's saying is that in practice the revenue would allow the costs of the accounts and then the costs of doing the tax computation, simply because it follows on, although that may be a matter of practice, but not the costs of arguing about it later. That's the distinction that's being drawn. But he also bases it on he's acting as a taxpayer rather than as a trader, if you look in the middle of the page. whatever you think of them, Murray, these are the principles that were being, my point is, they're principles that are being applied in Von Glen, and they are continuing to be applied by the House of Lords subsequently. And indeed, I think we'll see, I think Lord Radcliffe in the later case refers to the fact these have been applied many times in many cases. I just finally, Lord Norman, can I just take page 1515? It's the very first few, beginning with the very first, last few words. The reason why income tax is not deductible in computing profits is not merely the logical difficulty pointed out by Mr. Grant, that if it were, the computation would inevitably drift through the repetition of the deduction into the eddy of an indefinite process. Just to be clear, he's talking there about not the costs of fighting it, the costs of actual income tax. And the point he's making is that that would produce an infinite regression, because if you deducted the cost of income tax, then the amount of income tax would reduce, and therefore you have to change the computation every time. It would continue indefinitely. So it's logically impossible.
It's interesting the way Lord Simmons puts it on page 1513, when he, about 12 lines down, he says that, talking about the taxpayer, he's saying he would have earned no more and no less if there was no such thing as income tax. His profit is no more affected by the exigibility of tax than is a man's temperature altered by the purchase of a thermometer. Now, one might, and I suppose one might say the same about a regulator.
Exactly, I think that's right.
You know, that the trader would have earned no more and no less if there was no such thing as GEMA or Ofgem.
Yes, exactly. And equally, the trader in Von Glen would have earned no more or no less if it wasn't. If we didn't have the customs regulations, which meant that they had to pay a penalty because they couldn't prove where the goods had gone. So, sorry, Lord Norman, so although he recognises that illogicality on page 1516, he then goes on to say there is a more substantial reason than that income tax is an impost made upon profits after they have been earned, and unless the observations of Lord Davy in Strong and Woodfield, which has often been referred to and applied in later cases, are to be disregarded, a payment out of profits after they've been earned is not within the purposes of the trade carried on by the taxpayer. So, even in the case of where there is a illogicality, he says there's actually a better reason why it's not deductible, which is Lord Davy's reason.
That can't be a timing point, because you may well pay damages for breach of contract years after the breach, or years after that year's profit has been calculated, but you can still deduct those, I think you say.
Yes, I don't think he's making a temporal point. I think it's a conceptual point. The tax is levied after the profits have been earned and struck.
And I'm not sure it's just not restating the problem rather than proposing an answer.
Well, Lord Hoffman seemed to think that in, we'll see, or you'll have seen already, Lord Hoffman seemed to think that. But if it is, then a lot of judges have made that mistake. And in my submission, it isn't restating the problem. There is a substantive point being made. Lord Hoffman seemed to think that just meant you didn't deduct it in computing profits, but that's profits for tax he's talking about.
So what was that again? So take me over that again, please. Sorry. What did you say? I just missed.
Lord Hoffman's point was that whether it was paid out of the profits depended upon whether you deducted it in computing the profits. But that's computing profits for tax. Whereas I think what they're talking about here are the commercial profits that a company makes. They're not talking about the profits computed for tax necessarily. They're saying that income tax has nothing to do with earning profits. And in other words, you do things to earn profits, the profits being what the company makes.
But you run an inn to earn profits, the chimney falls down on somebody in the inn, and
yes.
you have a liability. And I don't follow it at all. The explanation was that was money paid out of profits that had already been earned. Well,
that was out of well, yes, exactly.
But of course it was. But so what?
Yeah, I think I think many people have found difficulty with that particular factual example. Some distinctions seem to be clearly drawn in the minds of the whole of the House of Lords between your liability as a trader and your liability as a householder.
But exactly. There seems to be a distinction between carrying on the trade of a publican on the one hand and being an occupier of
yes.
premises on the other hand.
Yeah.
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 Yes, because one of their lordships contrasted this with if the chimney had fallen into the street to a passerby.
From the flat above the grocer's shop, I think was his example.
Yes.
Then it wouldn't be
Then it wouldn't be deductible, but he
whereas
was less sure about the facts, but he wasn't prepared to dissent.
I think it's the other way around. Yeah. I think they were saying that if it had fallen on a passerby, it would have been even more obviously
not deductible.
Not deductible, yes.
The difficulty in the case only arose from the fact that it was a customer of the pub who was injured.
There, yes. Maybe that was regarded as happenstance, that it happened to be a customer. It could have been anyone. Whereas the other example they give is someone being injured while they're on the train, actually. But then they would probably be liable in contract to them, I suppose.
Yes, well, he accepted the deductibility of compensation paid to the passenger injured in an accident.
Well, I'm not sure he went all the way, but he certainly suggested that might be a different case. Yeah.
But for your purposes, all you need to do is to establish a rule of public policy that the words wholly and exclusively are to exclude penalties.
Well,
do you have to go? I mean, there is an abundance of various tests, but which is the test that you espouse?
Well, we say that both would apply and both would create non-deductibility, which is not an unusual...
You say what?
Sorry, both approaches, both the Court of Appeal in Von Glen and Lord Hoffman's rather different approach, both, we would say, there's no reason, they're not inconsistent with each other, they're simply two ways of getting to the same answer in tax. And they're both supported by... Well, the Von Glen approach is supported by a considerable amount of authority, and Lord Hoffman's approach is supported by Lord Hoffman, and the unanimous House of Lords, of course, in that case, who all agreed with them. But I don't think that approach has been suggested before Lord Hoffman, the public policy approach. But I'm simply dealing with the first of these now. As I said, Mr. Chacko is going to deal with the public policy argument. But our point on that is just as much, as I think your Lordship was saying, just as much an aspect of the wholly and exclusively provision as what we're looking at now. It's not a separate, wholly freestanding, judge-made rule that says public policy means you don't get a deduction for tax. And we would agree with the respondents that would be unconstitutional, actually, to say that tax can be imposed other than by Parliament.
Yeah. I mean, all the cases are about the interpretation of essentially the wholly and exclusively provision. And Lord Hoffman is really trying to rationalise why that provision is interpreted the way it is.
That was what we would submit, my Lord, and I hope we demonstrated in our case, we went through the various stages of that decision in some detail, so that I wouldn't have to do that today. But they show that the argument was all about the wholly and exclusively rule, all the way up to the House of Lords. And indeed, Lord Hoffman was dealing with one of the arguments by the Crown on the wholly and exclusively rule when he came to his public policy point. The argument being essentially what we discussed earlier, that the penalties are not deductible, therefore the expenses must be non-deductible as well, as in Von Glen. And he rejected that because he said there was a different policy involved in the penalty and the legal costs of resisting it or challenging it. But it was all about what is now Section 54.
But you wouldn't support a test that says, yes, of course you can regard this as wholly and exclusively incurred for the purpose of the trade. Yes, it fulfills that, but for public policy reasons, we're not going to allow you to deduct it. That's not
our case. I mean, at the very end of our written case, we have dealt with the possibility of that, because obviously we have to cover every possibility, but it's not our case. And frankly, I think certainly down south, you could say they fought a civil war over the question of who could impose taxation. But anyway, we say it has to be grounded in a statutory provision. So can I just then briefly just take you to the other
revolution in the colonies as well?
Sorry.
Yes. There's a revolution also in the colonies.
Yes. Yes, that's absolutely right. Smith's IRC and Dowdle, which is begins on page 996. I think I can deal with that reasonably quickly. This is it followed on from Smith's Potato Estate, because this was about foreign tax being deductible, foreign tax on the profits. So tax was levied in Ireland on the same profits, and the question was whether that could be deducted in computing income tax in the UK. And can I just take you to page 1004, which is Lord Oaksey. It's just a paragraph beginning on the first question. Just to clarify this, there were two issues in this case. One was whether it was deductible on general principles, and the other was whether there were particular statutory provisions that meant it was deductible. I'm not going to look at the latter point. And then Lord Reid on page 1006. Here he is dealing with the paragraph beginning, it was argued by the respondents, this is a question of fact, and therefore the decision of the commissioners on this matter is final. The commissioners, in this case, the first instance commissioners, had decided that it was wholly and exclusively for the purpose of the trade. He says, I can't accept this argument. Certain payments made by the taxpayer of such a kind that they are capable in law of being regarded as coming within this exception. No doubt it's for the commissioners to determine whether the circumstances are such that they in fact do come within it. But it is, in my judgment, a question of law whether particular payments are of a nature capable of coming within the exception, and that is the issue here. We would say that's the issue also in this case. And then Lord Reid essentially applied what was said in Smith Potato Estates, and you can see that on page 1012, just about a third of the way up, where he says, I think the matter is put beyond doubt by the reasons given by the majority of this House in Smith's Potato Estates in Boland. And his analysis of that is on page 1014, just that right near the end, where he says, my lords, I trust I have not misrepresented the speeches, and he says he's read them over and over again, and they appear to establish conclusively the distinction between money spent to earn profits and money spent out of profits, which have been earned, and secondly, the fact that income tax and excess profits tax payments come within the latter category. So, and then Lord Radcliffe, the passage that I was referring to earlier, page 1017, he first makes the point that Lord Readon made, that he thinks that the commissioners had erred in law in concluding that it was wholly and exclusively. You can see that about a third of the way up the page. Because their view is in conflict with what Lord Davy said in Strong and Woodfield.
So what page number again?
Sorry, 1017.
Thank you.
And then over the page he says, referring to, he says, there is much to be said for the criticism that Lord Davy's speech in Strong and Woodfield imposes too limiting a criterion as to what is permissible deduction by way of trade expenditure, but I do not know a wider one that is not vulnerable in other ways. And the fact is that this criterion has stood for so long and been so often applied that it has become, as it were, part of our income tax language. It led directly to the decision of the Court of Appeal in Rushton Hill and the decision of this House in Smith's Potato Estates. And then he goes on to deal with the argument that various statutory provisions lead to a deduction. And he refers, I've never heard of this before, at the bottom of page 1018, to the Parliament concealing their intentions with more than a Baconian obscurity.
Further up,
Bottom of 1018.
further up the page, he, in the first full paragraph, about halfway through it, he says that the criterion is the purpose of which the expenditure is made in relation to the trade of which the profits are being computed. So he sees it as being a purposive test.
Yes. And the final point really to make on this is the question of duality. Because I think
they have to, I don't know whether the electricity companies have to pay an annual sum to the regulator to help pay for the costs of the regulation. But that presumably is deductible.
yes, because that's something they need to pay in order to earn profits. They can't trade without that.
Yeah.
Rather like a practicing certificate or
Yes.
a lawyer.
Yeah.
But on the other hand, if you are fined by the regulator, you wouldn't expect to be deducting that from your profits for doing something wrong. The final point was about duality, because it is said in some way by the respondents that they had a trading purpose in paying these amounts to the regulator. But that's not good enough, of course, because it has to be wholly and exclusively for the purpose of the trade. So if there is a non-trading purpose, then you can have as many trading purposes as you like, but it doesn't help you. And we refer in our case at paragraph 121 to the case of McKinley and Arthur Young, which is a passage which is quite a useful summary of the position.
I'm so sorry, can you give me the page number again?
Yes, sorry, it's paragraph 121. I'm just trying to find it myself. It's page 59 of the key documents bundle, if you have that. Where we said, Lord Oliver says, much argument has been addressed as to whether the purpose of a particular payment falls to be ascertained objectively or by reference only to the subjective intention of the payer. Sorry, that should be intention, I think. For my part, I think that the difficulties suggested here are more illusory than real. The question in each case is what was the object to be served by the disbursement or expenses. As was pointed out by Lord Brightman, in Malalieu's case, this cannot be answered simply by evidence of what the payer said he intended to achieve. Some results are so inevitably and inextricably involved in particular activities, they cannot be said to be but a purpose of the activity. in my submission, that chimes with what Lord Reid and was it Lord Radcliffe were saying in the earlier case, that even if the commissioners decide, as a matter of fact, that was what was in your mind, that doesn't conclude the question as a matter of law. So can I just finish before I hand over to Mr. Jackal? McKnight and Shepherd, as I said, we've dealt in some detail in our written case at paragraphs 92 to 104 with the various stages of this litigation. By the time the case reached the House of Lords, it was only the legal expenses that were in issue. The penalties imposed on the taxpayer had been an issue in the Commissioners and the High Court, and they had both decided they were not deductible, essentially applying Von Glen. But the Court of Appeal, I think the taxpayer only appealed on the legal expenses. It may be a sign of the times, but in Von Glen, the penalty was much greater than the legal expenses. But in McKnight, the position was the opposite. The legal expenses were a lot greater than the penalty that was imposed. And so they appealed, the taxpayer appealed, on the penalty, on the legal expenses issue to the Court of Appeal, in which he was successful. And then the Revenue appealed to the House of Lords. And it was in dealing with that appeal by the Revenue, you'll see that Lord Hoffman introduced his policy criteria. But all I wanted to do was just to say, that we do not agree with his criticisms. While we agree with his decision and we agree with his alternative reasoning, we do not agree with his criticisms of the reasoning of the Court of Appeal in Von Glen. This is at page 1198. And you'll see that the paragraph just above C, he says he's no doubt the decision was correct, but then that they were curiously inarticulate. And he sets out some of what was said. And then he makes the point afterwards. He says, to say the payments followed after the profits have been earned is only one way of saying they could not be deducted in a calculation of profits. Well, in my submission, that's not a fair criticism. It restates the question rather than explaining the answer. Von Glen's case was not like Smith's potato estates, in which it would involve an illogical circularity to treat the expenditure as a trade expense. Well, first of all, it wouldn't have been illogical. But in any event, as you've seen from Smith, even though that was recognised, the House of Lords regarded it themselves as deciding it on the basis of their principle in Lord Davy and Strong and Woodfield. So, in my submission, the reasoning of the Court of Appeal in Von Glen is still is good law, and is one way that you can come to the conclusion that these are not deductible. These payments were not incurred for the purpose of earning profits in the trades of the respondents. Put another way, they were not incurred as traders, but personally, out of their obligations of a public rather than a private nature under the Electricity Act and the Gas Act. And it's not enough for deductibility that the payments arose from or were connected to trading activities. And finally, and just to state the obvious, there's no suggestion that the respondents breached their licensing conditions with the purpose of earning profits in their trade. It's always been the case that they did this inadvertently. And in any event, it would have been impossible, because as we've seen, the payments are calibrated, or the penalties payments are calibrated to ensure that they will always be worse off as a result of breaching the licensing conditions.
So they might have said, oh, let's not employ any more people in the complaints handling phone answering service. We'll save the salaries, and if we get fined, well, so be it. The idea is to prevent them from making that calculation.
Yes, well, but they didn't do that in this case.
No, but
No.
in a different.
But if they did that, they might get in under what we've been discussing, but they would certainly have a problem with the public policy issues, which I think Mr. Chacko is now going to address. Shall I get out of the way?
Yes, Mr. Chacko.
Thank you, my lord. So, Von Glen and McKnight both took the view that taxpayers could not claim deductions for paying penalties. We say that neither case saw this restriction as a specific judge-made rule, saying something like, you can't get a deduction for a penalty, in the way that there's a section that says you can't get a deduction for business entertainment. If we had a rule like that, we'd be arguing about, well, what is a penalty, what's within that phrase? But that really would be judicial legislation. Rather, the judges in those cases saw this as an application of more general principles of tax law. Mr. Ewart has explained how the restriction on deducting payments of this kind follows from the rule against deducting payments which are not wholly and exclusively for the purpose of the trade, for two reasons, both because they're not paid in order to earn the profits, but are rather imposed on the taxpayer out of their profits, and because a punishment is personal to the person who's being punished, which means it's inherently a private expense and has a dual purpose, even if you enter into a settlement for commercial reasons. The cost is inherently a personal benefit to the person whose punishment it is. And so you get into the problem of mixed purpose. I'm going to address you on another principle which we say is being applied in these cases, which is what Lord Hoffman referred to when he explained this restriction in McKnight. And that's that this is an application in the field of tax of a well-established and much wider principle, what's called the narrow form of the ex turbi causa principle, that a person who has been punished cannot avoid or share the cost of that punishment by making claims under statute or civil law to escape it. I'm going to structure my submissions as follows. First, I'm going to look at the authorities and what the relevant principle is, the narrow ex turpi causa principle, against getting somebody else to bear your punishment, and explain why it applies to regulatory breaches such as the ones here. I'm then going to deal with the suggestion that it can't apply within a prescriptive statutory code, such as the tax system. I will then go to the Court of Appeal and look at what it said about the restriction on deducting penalties, and explain why they took the wrong approach. And finally, I'll address you on why this matters, which is for two reasons. One, that in this case, as Lord Hoffman explained in McKnight, allowing a tax deduction would effectively dilute the penalty. But also that these cases will emphasise the personal nature of punishment. And that's why the duality rules are engaged, because the cost of bearing that punishment is inherently a personal cost of the trader, not an expense of the trade. So if I might, I'll go first to what the rule, the narrow ex turpi causa rule is. There is a well-established principle in the law that if a person has been punished or sanctioned, they cannot avoid or share the cost of that punishment. It applies to claims in damages, and it applies to claims in contract, typically contracts of insurance. And if you go to what Lord Hoffman said in McKnight at page 1198 of the bundle.
Sorry, 11?
1198. This is page 1337 of the report at H. What he says is, the purpose of a penalty is to punish the taxpayer and a court may easily conclude the legislative policy would be diluted if the taxpayer were allowed to share the burden with the rest of the community by deduction. This, I think, is what Lord Sterndale meant when he said that the fine was imposed upon the company personally. And these two concepts, I said there's two concepts in there. First, that a punishment is personal to the person it's directed at, and that the second is that this entails that punishments shouldn't be shared out among other people, either by getting a contribution or a full indemnity. Run through the case law on this issue. So this is what's referred to as the narrow form of the ex turbi causa principle. The wide form is that you shouldn't gain a benefit from your wrong. The narrow form is that you shouldn't be able to escape your punishment. And that's actually set out also by Lord Hoffman, and he set it out in a case called Grey and Thames Trains, at paragraph 29 of that case, which is at page 884. And it's basically the second half of that paragraph. In its narrower and more specific form, it is that you cannot recover for damage which flows from loss of liberty, a fine or other punishment lawfully imposed upon you. In such a case, it is the law which, as a matter of penal policy, causes the damage, and it would be inconsistent for the law to require you to be compensated for it. Now, Mr. Goldberg has said at 8.7 in his written case that this rule can't be applied here because Scottish Power is not seeking a benefit. Rather, the default is that they are taxed on their accounting profits, and it's the revenue who are trying to impose an additional charge by adding a sum back into their profits. And I say this approaches the ex turbi causa principle in the way that was rejected by this court 10 years ago in Appellant and Mirza. Because in that case, what they had to decide was whether this was a rule that depended essentially on reliance to identify a claim which is relying on a wrong in some way, or is it a more general rule of public policy? And if I could take you to page 1376. At 101, Lord Toulson sets out what the current rule is, the passage starting at, in answer to that question, and gives an A, B, and C. So that's the modern form of it. And then if I take you to 110 and 111 of that decision, what he's saying there is that they're rejecting the approach that makes this a matter of procedure. So what they say is a party profiting from their wrong in some way, and would allowing them to do so be contrary to the public interest? In this case, we'd also say that the deduction for the expense is a benefit under the statute. The tax legislation allows deductions for expenses wholly and exclusively for the purpose of the trade. And that the fact that Section 54, as you've seen, is worded negatively, and that it says you cannot deduct anything which is not wholly and exclusively the purpose of the trade, shouldn't make a difference approaching these principles in the modern way, so that if it had said you can get a deduction which is wholly and exclusively the purpose of the trade, we'd be able to apply the ex turpi causa rule, but because it puts it the other way around, we can't. We'd say that that's the approach, the very procedural approach to ex turpi causa that was rejected in Appellant and Mirza. Realistically, a tax deduction is a benefit and the taxpayers are claiming it, whatever the mechanics are. Now, many of the leading cases are about serious crime, but the principle does not rely on the wrongful behaviour being criminal. The scope of the ex turpi causa rule, in terms of the kinds of behaviour that engages it, was summarised by Lord Sumption in the Apotex case at paragraph 25. That's at 1064 in the bundle.
Sorry, can you say the page number again?
1064. If you would read paragraph 25. So I'd say this extends the infringement of statutory rules enacted for the public interest. These are some of the things that Lord Sumption describes as quasi-criminal. And it's been applied to regulatory punishments. And there's two cases that have done this. One is the Court of Session in Khan and Hussain, and the other is the Court of Appeal in Safeway Stores and Twigger. Khan and Hussain, Mr. Khan was approved by the Financial Standards Authority to perform various functions. He provided false information on a mortgage application, and he was then had proceedings taken against him, and he was blocked from practicing. He then sued his accountant for loss of earnings because the accountant had encouraged him to make the false mortgage application, and he said, "Well, by having my license taken away, I've lost my earnings." And Lord Eric held that this breached a narrow ex turpi causa principle. I mean, the reasoning in that case starts at page 989, but I'm not going to ask you to go through it because it just basically says that the rule applies here, applying Grays, Thames Trains and Safeway. But I think it's interesting that that's a punishment from the financial regulator in a way analogous to that in McKnight. It also wasn't an indemnity against the fine. He was claiming the loss of earnings consequent on having his license withdrawn. So the form of punishment doesn't matter here. The point is, are you trying to get someone else to bear your punishment for you? Then in Safeway Stores and Twigger, that was a financial penalty, and there was a more extensive analysis from the Court of Appeal. Safeway was investigated by the Office for Fair Trade.
What's the page number, sorry?
Safeway Stores and Twigger starts... Well, I was going to take you to 1484, which is...
Thank you very much indeed, thank you.
Paragraph 16 in that decision. So they were investigated for anti-competitive practices in raising the price of milk. They settled rather than go to a hearing on it, agreeing that they'd be penalised, but then they sought an indemnity against the penalty from their former directors. And Lord Justice Longmore and Lloyd explained this engages the narrow form of the ex turpi causa principle. That's in 16. The narrow form for the indemnity, and then also was the wider form, so they also wanted to claim the cost of the investigation, which would have been a loss stemming from unlawful acts. But one of the things that's interesting about this case is how much they use similar language to the Court of Appeal in Vaughan Glen, talking about how important it is that Safeway is personally liable for the penalty imposed on it, and that's why they can't claim it from somebody else. You get that in Lord Justice Longmore at paragraph 23, and which is on page 1486. And Lord Justice Lloyd at 37 at 1489. Lord Justice Pill then approached it in a manner, directed in a manner relating to regulatory policy, and in language very similar to that of Lord Hoffman and McKnight, says at 44, that the policy of the statute would be undermined if undertakings are able to pass on the liability to their employees or their employees' insurers, only if the undertaking itself bears the responsibilities and meets the consequences of their non-observance are the public protected, a deterrent effect is contemplated. Now, this court commented on Safeway and Bilter in the case of Bilter and Nazir. There was a 7-justice panel. 3 of the justices criticised Safeway and 4 did not. The issue that troubled them in that case was that the ex turpi causa rule was being relied upon by directors as a defence to the company on the basis that the wrongs that they had actually committed on the company's behalf were being relied on to sue them. And that obviously throws up other public policy and legal concerns. None of those concerns arise here. There's no sense in which the general taxpayer, the general body of taxpayers, is responsible for the breaches of regulation by Scottish Power and therefore ought to bear some of the cost of that. So, are the regulatory rules here statutory rules enacted for the protection of public interest and attracting civil sanctions of a penal character, which is the language Lord Sumption used in Apotex? And we say plainly yes. Mr. Goldberg also refers to Apotex. He refers to paragraph 28, which is on page 1065. And I would ask you to read paragraph 28.
Yes.
The point about 28 is that what Lord Sumption means by quasi-criminal is the sort of thing he's already defined at 25 and includes regulatory infringements. And I say that these are not private infringements. Mr. Goldberg, I think at 1.2.1 and 8.3 in his written case, says that they are analogous to breaches of contract because they are breaches of licenses. But as Ms. Stewart took you to this morning, the First Tier Tribunal recorded at paragraph 4 that it's an offence to supply energy without a licence, and the standard licence conditions are required to be included in the licences under statute, under Section 8A of the Electricity Act. So this isn't a sort of private contractual dispute between Ofgem and Scottish Power. Ofgem don't sue in breach of contract, they enforce using their regulatory powers. And so we'd say this is clearly a regulation imposed in the public interest. The taxpayers also suggest the breaches are not particularly serious and therefore wouldn't engage these rules, in the sense that they were not deliberate, arose in the course of their ordinary business, which of course was also true in Von Glen, as you've seen, and were difficult to avoid. But we say it's not appropriate to get into an argument about how serious the misconduct was. The regulator dealt with that and held it was very serious. I mean, trivial misconduct would not give rise to payments of this scale. The appropriate level of penalty was in the millions, and this was never avoided or removed. We say it was paid in another way. There was nothing that reduced the amount that they would have to pay.
I wonder if it might be said that when you look at Patel and Mirza and the more recent cases in the same line, like Henderson and Dorset and Lewis Ranwell, the court has focused on whether allowing the cause of action would be inconsistent with another aspect of the law. And that seems to be the same essential point as Lord Hoffman was making in McKnight, where he asked whether allowing the payment to be treated as tax deductible would be inconsistent with the legislative policy which justified the imposition of the requirement to make the payment in the first place.
Yes, I mean, that's why, my Lord, we say that I think that what Lord Hoffman is actually expressing a version of this, of the extirpi causa.
Well, one might, I mean, it's not, I don't think it's strictly speaking, it's not really quite the same as extirpi causa, but you might say that the rationale is related.
Yes, that it's a related idea, and the idea that, particularly that being able to avoid the full effect of a punishment by claiming a deduction is wrong for the same sort of reasons as these cases have said you shouldn't be able to insure against a punishment or claim contribution from under tort. I was just going to ask. I think it's 7-3. Would the court be willing to allow us to run into some of our reply? Because I think that I may not be finished in the next 7 minutes.
Well, it's a matter for you. Your reply time is an hour. If you want to eat into it now, then I don't think that's a problem.
Yeah. So.
Okay.
So on the basis that so much, if I run over, it will be taken out of that.
Yes. Mr. Goldberg won't lose any of his time.
So is it a problem to apply this in taxation with tax being a comprehensive statutory code? And we say no, this isn't a problem, and that was rejected by this court in Welling Hatfield. That was a case about planning law. The statutory regime said that there was a 4-year time limit for infringing planning rules by changing a building its use as a dwelling. A builder obtained planning permission to build a barn. He built a barn that had a house inside it, and then after 4 years, he told the council and asked for a certificate of lawful use, saying that he had been doing this for more than 4 years, so they had to approve it. And the Court of Appeal held that that he was right. Interestingly, the Secretary of State agreed and thought this was right, but the council appealed, and this court said it would allow the builder to profit from his wrong if he could obtain a certificate through kind of deliberately sort of manipulating the statutory code in that way, despite planning being a comprehensive code. And
I'm wondering why it is that one needs to go into these cases, because if the policy of the legislation that we're looking at is that the individual who is to be punished is punished, why do we have to get into extirpi causa? Why not just rely, as Lord Hoffman did, upon the policy of the legislation?
I think because extirpi causa explains a problem which the Court of Appeal had here, which is they said, what is this principle that Lord Hoffman is referring to? Is it a sort of freestanding rule? And we say no. It isn't like there's a judicially invented rule about penalties that exists in the tax code.
He didn't invent a rule. He said that the purpose of this payment wasn't wholly and exclusively in relation to the trade. It was a personal payment fulfilling the policy of the law, of the legislation. And
I think we agree with that, but the Court of Appeal didn't. It said that it wasn't part of covered by wholly exclusively principle. So this is, in a way, this is relevant for two reasons. One is that we say it would infringe at least a similar rule to extirpi causa, in that it allows a partial indemnity against punishment.
So you mean this point is relevant if we are against you on your wholly and exclusively point, and if we say this is actually wholly and exclusively for the purposes of the trade, then as a fallback you rely on extirpi causa narrowly, the narrow meaning to say even so it shouldn't be recoverable.
Yes.
Deductible, I mean.
Yes, I do say that. But also that the concerns in these cases about how a payment is personal to the person who's punished and shouldn't be moved to someone else explains why it is that bearing the cost of a punishment has a dual purpose, because even if you have commercial purposes as well, as in Mallew and Drummond, there were commercial reasons for Miss Mallew to get a suit for court, it is an inherent purpose of wearing the suit that it gives you a private benefit. It's an inherent purpose of bearing the cost of the penalty that it benefits the person whose penalty it is, because it's personal for them. It can't be moved around. And that's why the other reason we think these cases are relevant, because they emphasise that that's true. That comes from the nature of a punishment. It's not something special about statutory penalties.
So, sorry, just to push that. So you say it's because of that, because of the narrow maxim, that's why it has a dual purpose, because its purpose is to take your punishment in a personal capacity.
Exactly, my lady. So in a way, it's inherently a private. It's in the private capacity of the person carrying on the trade, not in the capacity of them doing their trade, because that's what punishment is. I'll give you the sections in Welling, which are just 50, where he says he will apply it even within a comprehensive code, and 53, where he says this is a matter of interpreting the statute, in that he says your Parliament cannot have intended in the planning legislation to allow you to get a benefit in this way. And that's the sort of observation that's made all the time in tax legislation when applying, for example, what's called the Ramsey line of cases, that Parliament cannot have intended you to be able to manipulate the statute in such a way. If I might now go to what the Court of Appeal said and where we say that went wrong. So if we go to page 108 in the Corban, this is the Court of Appeal's decision, at paragraph 49, so at 49, Lady Justice Falk, she cites Lord Hoffman's concern about sharing the burden of a penalty. But then at 50 and 51, she explains why she doesn't see that as an example of the wholly exclusively rule. I mean, the reason she actually gives for that we'd disagree with, which is that she says, well, wholly and exclusively is about the taxpayer's purpose or object, citing Malnew and Drummond, rather than the character or nature of the payment, which is the issue in Von Glen. And we say that isn't actually right. I mean, Malnew and Drummond was itself a case where they said that it was in the nature of paying for your clothing that one of your purposes was going to be warmth and decency, whatever you thought about it. And so similarly, I mean, Mr. Ewart took you to Lord Reid in Dowdall saying it was a question of law. The reason it's a question of law is that it isn't just a matter of what the taxpayer thinks about the expenditure. There are expenses, such as clothing, where in their nature they will have a private purpose. And we say that's the case here as well for the punishment. But then at 52 to 54, her analysis is that this is a judge-made rule, but that's all right as long as it's clear, and it's also one of very long antiquity, because it dates back to Von Glen. At 55 to 56, she says it's about not diluting the legislative policy, and that must mean it's the legislative policy behind the penalty, and so it must only apply to statutory penalties. And she does note that that means that it wouldn't have applied in McLaren, where the penalty was under the rules of Formula 1. It also wouldn't have applied in McKnight itself, because that was before stock exchange rules were put on the statutory footing. And I submit that's a surprising result and suggests something has gone wrong in the analysis. That leads her to her framing of the rule in Von Glen at 58 onwards. 59, she says, such a rule exists in relation to the deduction of fines and penalties, at least where they are imposed under a legislative regime. However, there is no support in the authorities for that rule to extend to amounts which are not in fact fines or penalties, and then explains why she says extending the rule, as she sees it, would be uncertain. At 60 to 62, she identifies one uncertainty, which is she says that it can't be that simply replacing a penalty that wouldn't be deductible with something else means that other thing is going to be non-deductible as well. And at 68 and 69, these were some issues that were asked about this morning. She says, well, the settlement itself requires Scottish Power to improve its compliance. That will cost money, but they're not being forbidden a deduction for those improvements. And similarly, if they had voluntarily made redress payments to their customers before the investigation started, those would probably also reduce the level of penalty, but they probably would have been deductible. And we say that these stem from a misunderstanding of what the rule was. It's not a judge-made rule stating specifically that no fines and penalties can be deducted. Rather, it's an instance of a well-recognised principle about how you approach punishments. That's why it didn't matter that in McKnight the regime wasn't statutory. That was still the recognised way that stockbrokers were regulated and punished, and he was being punished. And you see this at 68 in her decision, where her approach seems to be that because this isn't a statutory penalty, the revenue's position must be that it's not deductible because it's something Ofgem took into account when reducing the penalties to £1. And so she will then, at 68, 69, talk about other things Ofgem also took into account and says, well, they're deductible. And we say the sequence that this gets the sequence wrong. I mean, you've been taken to the complaints handling letter, which made clear that the appropriate penalty before discounts was 23 million and then discounted to 18 million. And it's not that you then take into account redress payments to give like a 99% discount on the rest of it. That's how you meet the 18 million. It's not a further discount. I mean, this is stated explicitly when dealing with the carbon dioxide penalties, where there's a similar letter, but Ofgem are asked, well, can we reduce that 2.4 million penalty further? And they said there's no mandate to do so. This is page 413 of the bundle. I mean, you'll actually see at the beginning of 4.1...
So I think you accept in 69, you accept that, yes, if they take on more people as a result of criticisms and the fines, or if then they could deduct that expense. And if we had discussion this morning, if they pay out at a very early stage of the investigation, or they pay out and get a compensation and get a reduced fine because they've shown remorse and tried to do the right thing, that could be deducted. But you don't agree that means that the dividing line is so unclear that it can't be a rule, is that?
No, because we say that what's going on here, in those cases, that's clearly not how the regulator is punishing them. You're not being punished by being told this is the acceptable number of complaints handlers to employ. You're being told how to comply in future, and that's a cost of trading. But what the authorities have said is that the cost of your punishment is personal, and in these settlements, the 18 million is the punishment. Well, in the complaints handling, they don't escape that punishment by paying it elsewhere. The agreement is about how it's going to be met. You can't read the documents as saying, well, Ofgem, after threatening them with a £23 million penalty, decided that in light of how generous they were being to their customers, they'd get a slap on the wrist and it would be £1. The seriousness hasn't reduced. The appropriate level hasn't been affected. This is how the penalty is actually paid. And we'd say they're not being let off anything. And so that's why, unlike those other examples, this is still their punishment, which is what the first tier found at 134 to 135. And in fact, as it found at 130, it said objectively, this is in the nature of a penalty. It's suffering imposed on you because you breached the rules. Those other examples aren't suffering imposed on you because you breached the rules. And that's what the FTT meant when it said these sums took the place of penalties. It's not that they replaced them in the sense they then weren't punished. It's that this was what did the thing the penalties would otherwise do. This was the deterrent. This was the appropriate sanction. Mm-hmm. But Ofgem considered that it was more useful for their purposes that this went to customers than that it went to the consolidated fund.
It's interesting, in the discussion in the Court of Appeal, in paragraph 49, Von Glane is said to have established that a penalty or fine incurred under a regime such as the one considered in that case is not deductible, even where it was incurred in the course of trading activities. And then in paragraph 58, we're told that the court recognised in NCL that a rule that denies the deduction for expenses that are not only incurred in the course of trading activities, that are taken into account in calculating profits, etc. It seems to be taken for granted in these paragraphs that we're dealing in this case with expenses which were incurred in the course of trading activities.
Well, I would say
that's I mean, it might be right or it might not, but it's not obvious.
I think it's in the sense that they were in Von Glen. In the sense that they were in Von Glen, because in Von Glen, there's nothing outside the ordinary scope of their trade when they put the goods on the ship to Russia. So in a way, and this is what's talked about in Von Glen, this flows from their ordinary trade. It comes out of that. There's a passage in...
Yes, but I wonder, I mean, the assumption that Lady Justice Falk is making, I think, is that we're dealing in this case with expenses incurred in the course of trading activities. And if that's right, that gets the taxpayer quite a long way home, but that starting point isn't really being examined.
I think, as Mr. Stewart took you to earlier, the underlying activities in the sense of paying for complaints handlers, sending people around to sell contracts.
Yes, but she's not talking about the acts or omissions that gave rise to the penalties, and she's talking about the penalties as expenses incurred in the course of trading activities.
Yes, and I would say that they're not, unless you take that meaning in the same way as in Von Glen, which is the underlying behaviour is in the course of trading activities. The penalty isn't. The penalty is imposed, as in this is what they held in Von Glen,
yes. And
she is quoting Von Glen, applying Von Glen there. The penalty was imposed as a consequence of trading activities, but I think it's put quite well by Rowlatt, approved by just dig it up.
Yeah.
Yes, if you go to page 730 in Lord Sterndale, it's where he says, of course, as Mr. Justice Rowlatt said, in a sense, you may say it was connected with the trade, because if the trade had not been carried on, the penalty would not have been incurred. There would be no opportunity for the breach of the law which took place. And that's the sense in which in Von Glen these are incurred in the course of trading activities.
So it's not, is what they're saying is it's not enough that it's incurred in the course of trading activities. It has to be wholly and exclusively for the purpose.
Yes, because that's what they're applying.
Yes, so they're contrasting that wording in the course of with the more stringent test that's required in the statute.
Yes. And so we say the actual question is this how they're being punished? I mean, Justice Falk said that there was no power, Ofgem had no power to redirect penalties away from the consolidated fund into charities and consumer redress. But we say they did have that power because what they did here was not unlawful, and that's effectively what they did. It was agreed what the appropriate level of penalty was, the breach was conceded, and it was agreed where the money would go. And this is described to the public in the agreed notices between the parties as if it's a single passage and that's the punishment that they're getting to deter other people. And we've set out those passages on page 35 of the bundle in our written case at 29. So I'd say it doesn't matter, that's how it was described at the time. And so, on that basis, we'd say, simply as an application of the rule in Grey and Thames Trains, if this is their punishment, they shouldn't be able to get a deduction that would reduce that punishment. But also, because this is their punishment, it's personal, and therefore meeting that is an inherently private cost that brings in duality. So we'd say on either basis, the payments are not deductible. This takes us on to the final point we deal with in our written case, which is even this is a freestanding rule, we'd say the FTT was right to say it covered the payments in this case. You can partly see that by the fact that if it was as narrow as the Court of Appeal said, it wouldn't have applied even in McKnight. But if it is a rule of public policy, you have to ask what that public policy is and whether or not these payments fall within it, rather than just say it's a rule of public policy which must be construed very narrowly. And in this case, as is the first two explained at 130, they looked at the nature of the payments. They said, well, these are in the nature of penalties, sort of as a matter of objective reality, and they considered what the nature of penalty was. And so we'd say there was no basis for overturning that. So, does that matter?
Yes, thank you very much, Mr. Chacko. Yes, Mr. Goldberg.
Ladies, my lords, I've been doing this job for about 55 years now, yes. And it's the first time that I have come across a case where a deduction has been denied for a payment on the ground that although it wasn't a penalty, it could have been. You can go through the cases, you won't find any case that is authority for that proposition. And this court is being asked to invent it. And it's being asked to invent it after Section 46 has been enacted. And there really is no basis for inventing it. It's a bit like the lady who goes to the lecture on gravity by Professor Einstein. And after it, she says to him, I was very surprised to hear that the sun holds the Earth in place by gravity, because I thought everybody knew that the Earth was held in place by an elephant standing on the back of a turtle. And Professor Einstein says, oh, that's very interesting. What is the turtle standing on? And she says, you can't fool me that way. It's elephants and turtles all the way down. There really is no basis for the proposition that the revenue are putting to you. There are three striking things about this case that show that redress payments should be deductible. The first is that, leaving aside any question of penalties, on the facts found by the FTT, the case for deducting the redress payments is irresistible. The commercially right answer is that the redress payments are deductible, They are a normal and, in many cases, a more or less unavoidable cost of doing business. And that is so even when the question of penalties is taken into account. On Friday, and I hope I might be forgiven for handing in these papers yesterday, but on Friday last, there was an announcement by Ofgem that it had reached a settlement with British Gas in relation to a different breach of the regulations from that in this case.
They used redress orders. They used redress orders.
They didn't use redress orders, my lord. They reached an agreement, and they did it without any penalty. And we've got the papers here which we can hand in.
But why does it matter?
Why does it matter? It illustrates some of the difficulties in my learned friend's argument, because some of the points you have been putting to him are dealt with in these papers. If we can.
How does it impact on statutory interpretation?
It impacts on whether it's wholly and exclusively for the purposes of the trade. The fact, and it also illustrates that there is that these sorts of payments can be made irrespective of whether there's a penalty or not. So that the payment has nothing to do with it. If your lordships don't want to look at it.
No. Do you have a copy for Mr. Ewart?
Oh, we provided it to Mr. Ewart first thing today.
Yeah. Well, unless Mr. Ewart has any objection to our looking at this, no? Oh, very well. Yes.
So we see that in recognition of Ofgem's findings, British Gas has agreed to pay a 20 million payment into Ofgem's voluntary redress fund. That British Gas has agreed to a settlement package which includes compensation to affected customers in the periods 2018 to 2021. In addition to the compensation, British Gas has already proactively paid to affected customers in the period 2022-23, writing off up to 70 million of energy debt for vulnerable customers in accordance with a framework agreed by Ofgem, a proportion of which may be used as compensation for some customers, continuing to provide the remainder of a 22.4 million voluntary package British Gas launched in 2023, aimed specifically at supporting PPM customers, creating a new panel, and so on.
Can I just ask you, Mr. Gilbert, the first document we have here is, I think, Ofgem's decision.
Yes.
Then we have, is it a press release by Centrica, which was British Gas?
Yes.
And the last one, where is another press release? Or
It's a press release by Ofgem.
Ofgem. Thank you.
So is the most relevant of those the decision document?
They're all relevant in showing how much is being paid away. And this case throws into question whether British Gas or someone else in the position of British Gas could get a deduction for those payments.
Yes.
My learned friend has given you, the court, no answers to that at all.
Well, so here you're saying the difference is that there wasn't the pound penalty. They don't mention a pound penalty.
There's no penalty.
Well, it might be said against you that Mr. Ewart's answer would be that it's treated in just the same way as the redress payments in your case. They are all in the form of a package to punish and deter for breaches, serious breaches of the regulations and licence conditions.
Why did my clients enter into it is the relevant question under
Sorry?
the statute. The relevant question under the statute is why did my clients enter into it? not why did Ofgem enter.
No, sorry, you said there's been no answer from Mr Hewitt as to what the position would be in the British gas case.
Yes.
And I was just putting to you that it might be said against you that the answer would be exactly the same.
It might be.
Yeah.
But my response to that would be it's very difficult to see why that should be the answer when there is no penalty at all. We need to look in a moment at exactly what Ofgem said when entering into the agreements which were entered into in this case. Because they very definitely did not say, oh, we'd like you to pay a penalty of 18 million, but we'll call part of it a redress payment. What they said was, we'll ask you to pay a penalty of £1 and redress payments of 18 million less £1.
Will we fully know unless we see the without prejudice offer that came and the deductions that were made from it and so on? There's going to be a whole lot of background to this, isn't there?
There is, but you're going to see some of the background to this when you look at the documents in our case.
Yeah. So they admitted responsibility and agreed to make a payment to Ofgem's voluntary redress fund.
Yes. But they also wrote off 70 million. And if you're going to call that a punishment, according to my learned friend, that's non-deductible. And that, my ladies, my lords...
I still haven't got my head around it. They wrote off 70 million of what? Sorry?
Debt.
In
They are writing off of up to 70 million of energy debt for vulnerable customers in accordance with the framework agreed by Ofgem.
Yeah, okay.
well,
It's not a question of that tax deducting that debt, though, is it?
I'm sorry. No, I'm asking the question, I'm posing the question. That sort of payment, is that deductible? You would expect, if you're a trader and you've bought in 70 million of debt and for some reason you write it off, you would expect to get a tax deduction for it. It's very odd if you don't get a tax deduction for it, but according to my learned friend, you don't.
well, evidently we can't. You can make what you can of this, but we can't decide British Gas's tax liabilities in this case.
No, but we can use it as an example, as it were, of the issues that arise on my learned friend's argument. So my first startling point is, when you look at the facts, and I've been diverted from it, but when you look at the facts, you're going to see that this is wholly and exclusively for the purpose of the trade, if we leave penalties out of it. And even when we bring penalties into it, it is still, in our submission, wholly and exclusively for the purposes of the trade. Secondly, HMRC are trying to tax an imagined world, not the real one. The redress payments were not penalties, and they weren't in lieu of penalties. And in our submission, HMRC can't pretend that they were, which is what they're trying to do. And thirdly, while we accept that there is a rule which prohibits the deduction of statutory penalties or payments imposed as penalties, there is no suggestion, no basis in the authorities for the suggestion that the rule has a penumbral spirit which extends it to agreed payments like the redress payments. And then HMRC have come up with the imaginative idea that the principle ex terpi causa applies in this case, which is a principle they only need if they lose on all the other points. The fact they've brought it in suggests that they know that their case is weak. In her now celebrated judgment in Hall and Herbert, Mrs. Justice McLachlan explains in a rather nice phrase that the law aspires to harmony. Unfortunately, HMRC aspire to disharmony, disingenuously claiming that they're seeking harmony, which they are not. The court has before it 4 sets of payments described as redress payments. The regulator, who is charged with the duty of regulating the gas and electricity industries, agreed the redress payments with the respondents and distinguished them from penalties. And I wonder if I can ask you to look at page 327 of the bundle. So if we look at paragraphs 1.3 to 1.6, the authority took into account that ScottishPower offered to settle this investigation and to make consumer redress payments set out in paragraph 1.6 to directly affected customers and to charities, third sector organisations for the benefit of domestic energy consumers. The authority also considered 2 representations or objections received on its proposed penalty. That's the £1. These representations or objections are discussed in paragraph 115. Having considered all the circumstances of the case, the authority considered that the consumer redress payments will be of greater benefit to consumers than if a significant financial penalty were to be imposed. Accordingly, the authority considered it appropriate in the circumstances of this investigation to impose a reduced financial penalty of £1, provided that ScottishPower pays the sum of 18 million less £1 in consumer redress on the dates and in the manner set out in paragraph 1.6 below, and then it sets out that 15 million has to be paid and 3 million possibly floats, but in fact went to the desired recipient. So there, and we'll see it over and over again in these documents, the regulator has made a distinction between the penalty and the redress payments. The unchallenged and agreed findings of fact made by the FTT are set out in the agreed statement of facts in the key documents file. And beginning on page 22. So maybe we should begin on page 21. The essence of SPEL's trade was selling gas and electric energy. The settlement payments to consumers and charities were a consequence of not meeting the standards required of energy suppliers. The acts or inactions that gave rise to the redress payments were part of the activity of SPEL's trade and were done for the purpose of earning income from that trade. This is a very important finding of fact, which is unchallenged. Lord Reid raised a question with my learned friend Mr. Chacko as to whether the penalty payments arose from the trade. In Herald Weekly, we see that the place to look in determining that is the root cause of the payment. And when we look at the root cause of the payment, this paragraph is telling us it's in the course of the trade. All of these paragraphs are telling us it's in the course of the trade, and they are filled out by the decision of the first-tier tribunal.
But in the course, being in the course of the trade isn't enough, is it? It's got to be wholly and exclusively for the purpose of the trade.
Well, this goes to show it's wholly and exclusively for the purpose of the trade. The first-tier tribunal found that as a fact, and it has been unchallenged.
Well, they found as a fact that it was wholly and exclusively for the purposes of the trade.
Yes, they did.
Which paragraph is that?
I think it is paragraph 1. (172) on page 160.
(172).
Yes, we found, you have to read this whole passage, but 172, we found that the other payments were not deductible on policy grounds. If we are wrong, we would find that Section 54 did not preclude their deduction. So that is a finding that the payments were wholly and exclusively for the purposes of the trade. And you see that if we start on page 158, there is a long discussion about whether the payment is wholly and exclusively, which runs through to page 172, to paragraph 170. In the olden days, I would have read this out loud. It's
we learned how to read some time ago.
it's incredibly important because the first-tier tribunal said, if we weren't against you on this question of penalty, we would have decided this case in your favour. And the findings of fact they made have not been challenged.
Well, is that a finding of fact at 172? Because they'd already found that the remaining payments were penalties. And I suppose what's being argued is that if they're penalties, they're not incurred wholly and exclusively for the purposes of a trade.
Yes. It might be said it's really a conclusion of law.
Yeah.
Yes, it might be said it's a conclusion of law, but all the authorities say, nearly all the authorities say, it's a question of fact as to whether it's wholly and exclusively. And unless there's some principle of law that they've gone wrong on, that is unchallengeable. And what is the principle of law that they have gone wrong on? Well, apparently, because there is some ethereal idea floating about that if this could have been a penalty but wasn't, then it's non-deductible as if it were a penalty.
Yeah. Well, the case of McKnight, which I mean, you know more about than anybody in this courtroom, having been counsel in the case, it suggests in the speech of Lord Hoffman that whether a payment should be treated as being wholly and exclusively for the purposes of a trade can depend on legal considerations as well as factual considerations.
That crops up from time to time. I was once walking with Lord Hoffman through the courts on the north side of Fleet Street because he wanted me to go and have a look at the statue of Dr. Johnson's cat that is there. And we were discussing what he was doing. He said he was writing a paper on failed judicial experiments. And he was going to use as a chief example Furness and Dawson. And I often think that what he said in McKnight might be another example. It doesn't respond to what the statute says. And it really wasn't the issue in the case. It isn't authority for the proposition. The real difficulty in this case is that the regulator did not, for the revenue, not for me, the real difficulty is that the regulator did not want these payments to be penalties. And he's made that quite clear. Can I, before I leave that, can I give the court some further references to the first-tier tribunal's decision? On page 149 of the bundle, in paragraphs 94 and 95, we see a further discussion.
So what page number, sorry?
149.
149, thank you.
Where they make the point that in determining whether something is wholly and exclusively, you have to go back to the root. Paragraph 112 on page 152 is another important finding of fact.
In what way? You say it's important. In what way? Sorry?
Well, if you are running a trade and it is overwhelmingly likely that you may have to make a certain type of payment in the course of running that trade, it is to be expected that it would be deductible. It's unlikely that you're going to be running a trade incurring non-deductible expenses. My Lord Reed this morning put the example of a taxi firm. And he said, it's inevitable you're going to have accidents. This is saying it's inevitable that the sort of accident that happened in this case, which is that we didn't answer the telephone quickly enough.
It's not inevitable that they're going to break the law, though. Taxi firms. There's a high chance of having an accident if you run a taxi.
Yes. Yeah,
but there's not a high chance, and it's not inevitable that you're going to breach your license conditions.
No, but the tribunal found that the infraction is practically almost unavoidable.
Yeah, that's because of how they chose to run the business.
Yeah, but
I mean, it seems very odd that as a responsible business you would have signed up to a license which contains conditions that were impossible for you to fulfill. It seems very implausible to me.
Well, I believe that in order to run a taxi service, you have to have a taxi license. And it is apparently more or less inevitable that you're going to have accidents.
But we're not talking about having accidents. We're talking about, for example, running a red light. Would you say it's inevitable if you run a taxi business that you're going to not stop at a red light, and therefore you should be able to deduct the fine?
But this isn't a fine. This is expressly
Well,
not
that gets back to the other point, but that's not the point. You're dealing with an unavoidability point here. So if you run a taxi business, you know that people tend to run red lights if they're in a hurry. Certainly, would you then say, so we should be able to deduct a certain proportion of our penalty payments for running red lights?
I'm not claiming to be able to deduct anything that is in form a penalty.
I think we were taken by Mr. Hewitt to material from our Ofgem, which suggested that I think 4 out of 10 suppliers had complied with all the requirements. And
Yes.
6 out of 10, including ScottishPower, had not.
Yes.
And it depended on how they ran their business.
It's a very common feature of running the business that there are these breaches.
Well, it's not a common feature if you employ enough claims handlers.
I'm sorry?
Well, but this is complaints handling rules.
Yes.
And your complaints procedures weren't sufficient because you didn't have enough people answering the complaints.
Yes.
So all you've got to do is employ some more people.
Yes, and we did. Once we discovered the point,
But it wasn't unavoidable. You could have employed sufficient people to have a proper complaints handling procedure.
well, I'm glad your lordship knows more than the first-tier tribunal who heard the evidence.
Well, but what they were saying is that it was practically unavoidable because of the way you structured your business.
Yes.
Not that as a matter of inevitability in every business it was unavoidable. So if you structure your business in a way that is going to put you in breach of your licence condition or in breach of a regulatory rule, that's a breach. It's not inevitable.
First of all, I didn't claim it was inevitable. I claimed
Well, you
that
said it was unavoidable.
practically almost unavoidable.
Well,
And the first-tier tribunal heard a lot of evidence, and they agreed with that. Now, no doubt, and they didn't agree with it on everything, but they did agree with it on complaints handling. And no doubt it is a very difficult part of the business of the company, dealing with it. But in any event, the revenue have to tax my trade. They're not taxing some platonic, perfect trade. They're taxing my trade. And unfortunately, I ran into some difficulties. That happens quite a lot when you're running a business. And you hope that you've not denied the deductibility. And the first-tier tribunal makes the point that I'm being reminded I should show you the previous sentence in paragraph 112. We find that infraction of the standards is not uncommon.
That's a sorry reflection, isn't it? That's a sorry reflection on the standards in the industry.
These are... I rang British Telecom the other day and got an answer. It amazed me. They deal with millions of complaints. And that's the reality.
But do you accept that if, on exactly the same fact, it being practically almost unavoidable that there were breaches, if in fact there had been penalties imposed, then those would not have been deductible?
I think I have to accept that, yes.
Well, so the unavoidability of it doesn't seem to me to have anything to do with whether it's deductible or not. It doesn't seem to have been part of the reason why Ofgem accepted that you deal with it by redress payments rather than penalties. That doesn't seem to have been part of the reasoning at all. Oh, well, we'll give you some discount or we'll let you do these redress payments because it was unavoidable for you to have a breach. So I don't really see what relevance the unavoidability has in this matter.
It's mentioned in Herald Weekly Tribune, Herald Weekly Times,
Yeah.
as a factor. I think as we go through the cases, we will see that the character in which you pay the sum is a material question in relation to, did you pay the money wholly and exclusively for purposes of trade? And in determining whether you incurred the expense wholly and exclusively for purposes of trade, a number of different factors can be taken into account. Can it be said that it is a payment made out of the profits after they've been earned? Can it be said that there is duality of purpose? Can you say that this was paid in a trading capacity or in a non-trading capacity? These are all factors to be weighed in the round in determining whether you have incurred the liability wholly and exclusively for the purposes of the trade. This is another factor that you take into account. Is the chance of error high so that you have to pay for the error? These are all part of the determination of whether something is wholly and exclusively for the purposes of the trade. But in the end, that is a question of fact. And all of these facts are in my favour. I think I've shown you page 152. Can I ask you to look at page 153, paragraph 119? Is a very important paragraph.
Isn't that a finding of dual purpose?
They did not find dual purpose. They found trading purposes for everything.
Yes, you rely, I think, on the last sentence.
Yes. Yes.
Oh, I see. Yeah.
Paragraph 199 refers to the purpose of closing down the investigation and avoiding adverse publicity, but there's no reference to avoiding the imposition of a penalty.
No.
Yeah. Well, that was one of the purposes, though.
No, they won't. The tribunal has not found that as one of the purposes, and it isn't open to this court to find it was.
Do correct me. I thought that the first-tier tribunal did decide that if they hadn't paid the redress payments, the penalty in the same amount would have been incurred.
That is not a finding that the purpose of the trader was to avoid the penalty.
Right. Yes. Okay. And it's the purpose of the trader. Yeah.
Yes.
What about paragraph 138?
Yeah.
That is not a finding of the purpose of the company. You'll see that the Scottish Power had a policy of paying redress to customers. You might say all of that was designed to avoid a penalty. Is that non-deductible? The tribunal has decided that that's deductible. It would be frankly astonishing if it wasn't.
And is it wholly and exclusively the purpose of the trader? So, for instance, the lady claiming a deduction for court clothes,
Yes.
In that case, she did have this objective purpose. She
Yeah.
didn't want to. She was only wearing those clothes for court purposes.
Yeah.
But they went beyond that to look at the real object.
The equivalent of the first-tier tribunal, the special commissioners, found as a fact
Yeah.
that she had a dual purpose. My tribunal did not find as a fact that my taxpayer had a dual purpose. They found it had a single purpose, and that was the purpose of the trade.
Where do we find that first-tier tribunal finding that there was a dual purpose in that case?
Oh, yes.
I'm sorry for asking you.
Will you give me a moment?
Well, no, deal with it tomorrow.
I can deal with it in the morning. No, that was the problem for Miss Manager. She didn't persuade the special commissioner that she only had one purpose. And, frankly, entering into the settlement agreement isn't like going naked in the street.
Is like what, sorry? Is like what, sorry?
Entering into the settlement agreement is not like going naked in the street, which was what Miss Manager, the choice if she wasn't wearing, well.
But would you agree that there are some payments where the question can't be answered only by looking at what the payer intends to achieve, but the results are so inevitably or inextricably bound up with what the payment is that you can look at it objectively, irrespective of the subjective views of the payer, and say it is a purpose of this activity to discharge the punishment owed, or the punishment that the regulator seeks to achieve?
I'm quite sure there are some payments where the objective facts suggest that the asserted subjective purpose is not true.
Well, I'm not talking about not true, but a dual purpose. So you've got a payment where the trader says, this is part of my trade. This is a regular incidence of my trade. I can't avoid this sort of payment having to be made. And that is true. But looking at the payment, it's so clear and inevitable that the payment looked at objectively is being made to discharge the punishment element of the regulatory activity.
Well, we haven't.
I'm not asking you in this case, but do you accept there is a principle where some payments can be looked at in that way?
I think I'm not prepared to go further than to say that may be so.
Maybe so. I'll live with that, thank you.
But, I grew up in a world where we asked the fact-finding tribunal what was the purpose. And in this case, the fact-finding tribunal said the purpose is wholly and exclusively that of the trade. And that is always the question. Was the expenditure wholly and exclusively for the purposes of the trade? A question which arises in this case, given the points which the court has been putting to me, is this. Supposing HMRC had been aware of GEMA's practice of entering into settlement agreements and had gone to GEMA and asked it to stop and instead to impose penalties. HMRC could have said, go and impose penalties, that's much better for us. The evidence, which we can see at page 140 of the key documents bundle, suggests that GEMA would have said no. It's paragraph 30 on page 140. We accept Mr. Sinclair's evidence that Ofgem's approach changed from imposing penalties to seeking settlement agreements involving substantial consumer redress payments, coupled with a nominal penalty. Thus, in 2010, some 15 million of penalties were imposed with no redress payments, and in 2019, the penalties imposed were some 2 million, but redress payments were some 50 million. This change is reflected in a number of statements made by Ofgem after 2010, where it stated that redress payments would be of greater benefit to consumers than the imposition of a penalty. And when we go through the documents that were entered into, which I'm afraid we'll have to do, we will see that that is a refrain that runs through them.
Just before leaving, doesn't section 54(1)(a), I haven't got it up in front of me, refer to the purposes of the business, not the purposes of the trader?
Yes. Yeah. It has to be for...
And so the subjective purpose of the trader isn't determinative. It's the object of the exercise. It's looked at.
It's material, though.
It's material, but you still have to define what the purpose of the transaction was, rather than the purpose of the trader.
I think the FTT has said the purpose of the transaction was to make profits.
The finding in paragraph 35A is that one of ScottishPower's reasons for the settlement was that settlement avoided the risks inherent in litigation, the possible adverse effects on its reputation of a large penalty.
Yes.
So the large penalty and avoiding it was one of the reasons why the settlement was reached.
Well, that doesn't mean it's the purpose of the payment.
Doesn't it?
I don't think it does, no. Anyway, why is this not the purposes of the trade?
Well, that's a different point. You seem at the moment to be saying it was no part of ScottishPower's purpose in making this payment that they thereby avoided the imposition of a penalty, and that's why you say it's not in lieu of a penalty. Now, that's a different point from saying, well, even if part of the purpose was to avoid a large penalty, then that's still a purpose which is wholly and exclusively for the purpose of the business. Those are two subtly different points, I think. Now, are you making the first of those points, or are you only making the second of those points?
Sorry, can you put those points to me again?
You seemed to be saying that it was your case that it was no part of ScottishPower's purpose in making the redress payments that they thereby avoided the imposition of a substantial fine. Is that what you're saying?
No, I'm saying it was no purpose of ScottishPower was other than a purpose of earning profits for the purposes of the business. And that is different.
Now, Mr. Goldberg, I see we're past 4 o'clock.
Yes.
Is that a convenient moment?
It's a very convenient moment. And I will
thank you
come
very much.
armed with Malinu and Drummond in the morning.
Incidentally, I think I can save you some trouble overnight. In the Malaliu case, I think the findings of fact you were referring to are at page 1152, and they are as you submitted.
Thank you very much.
Very well. We'll adjourn and resume tomorrow morning at 10:30.